to engage in this conversation. It's 8:32 a.m. On the phone, Martin Kpebu is a private legal practitioner. Kofi Bentil is also a lawyer, and he's with Imani. And Ransford Jampo is a professor of political science at the University of Ghana. Gentlemen, good morning to you all.
Yes, morning, Kojo. Morning. Tell me, dear, I always say I'm the rookie lawyer.
Well, rookie mponi and veteran there. All right, we'll be engaging our three guests on this conversation. Let's start by laying the foundation with this report put together by our legal correspondent Kweku Asante.
Speaker of Parliament Alban Bagbin took aim at the judgment of the Supreme Court that stayed its ruling on those 4 seats. He asked his lawyers to file an application to get that set aside. But even before that argument will be had in court, his lawyer was on his feet in opposition to one member of the panel, Justice Yao Enes-Gayewu.
He was known to be associated with the New Patriotic Party, and in fact he was a parliamentary candidate in one of their constituencies in the Volta region.
After listening to the arguments on both sides, the Supreme Court, the 5-member panel, did not agree with Thaddeus Sori, lawyer for the Speaker, that Justice Yao Enes-Gayewu should recuse himself from the case.
This court must take judicial notice of the fact that within the ranks of the Superior Court is a former member of Parliament for the National Democratic Congress, a former General Secretary of the People's National Convention. The subject matter of this suit before this court is a constitutional dispute and not a matter involving political parties. The objection is therefore misconceived.
The court then zoomed into hearing the substantive case. It first heard from Thaddeus Sori, who raised a litany of issues with the judgment of the Supreme Court, which he said should convince the same court to vacate that earlier ruling.
The writs or the processes on the basis of which the court's jurisdiction was invoked for the order are void because they were filed in violation of the rules of the courts.
All right, listen, let's get to it. And we're joined on the phones by Kofi Bentil, he's a lawyer. Martin Kpebu is also a lawyer. We'll be joined by Professor Ransford Jampo shortly. He's from the Department of Political Science at the University of Ghana. But before we hear... Oh, actually, we're joined by Prof. Jampo. Good morning, Prof.
Good morning.
It's great to have you with us. Let's start, perhaps, with Kofi Bentil. Kofi, this ruling, of course, is pleasing to the majority side, the NPP majority side, but there is a suggestion that the Supreme Court is exhibiting some sort of double standard, especially when it comes to the idea of representation, where they made that they filed that injunction ex parte, but insist that there is a need for natural justice. What are your thoughts on that?
Thank you, Kojo, and good morning to everyone. So my thoughts on that is that when you try to deal with hardcore legal issues from a political point of view, you will always get it wrong. If anybody has a problem with an ex parte application, then that person does not appreciate the fact that ex parte applications are part of law and they are part of the legal process, and there are rules binding or regulating ex parte applications. So the simple fact that somebody files an ex parte application cannot be a problem by itself. So for me, when we look at these things with political lens, it creates a problem. If we are going to deal with it in terms of the law, let's deal with it in terms of the law. There is no problem with an ex parte application. And that happens when an exigent matter is at hand and one of the parties feels that they must go to court so that they will be heard on their own, and they will convince the court why they had to come on their own. When the court makes an order, the order has an expiry. After 10 days, it lapses. And it gives the other party an opportunity to come into court within that time to set it aside or proceed as the case may be. So there is nothing wrong with ex parte applications. There's nothing wrong with the court hearing them. There's nothing wrong with the court granting them. When you have received an order based on an ex parte application, whether you like it or not, you agree or not, you respect the court, and then you make moves, instruct your lawyers to go and make the necessary arguments to have it set aside or to have your side of the case heard. For anybody to suggest that an ex parte application is some underhand thing that is aimed at some political advantage is not law.
Mr. Bentel, the argument is not that this is a strange practice in our courts. The argument, and of course, I need to point out that in this case, the ex parte that was granted was not for 10 days. It is to the entirety of the case being heard and finished. That's one point I need to point out. Secondly, let me quote Professor Kwaku Asare. He says, courts derive their legitimacy from the steadfast, even-handed application of the law. The moment they falter interpreting the same facts to support jurisdiction in one case but deny it in another, they chip away at public trust. Courts cannot extol the right to a fair hearing only to decide some cases in ex parte hearings. And that's the point he makes to back the principle, consistency, application of that in the instances that we have it.
In the first place, I am not sure when people say this ruling is not bound by the 10-day rule. I think the ruling said they should file their papers within 7 days, which means they can be heard within 10 days. Now, if you fail to do so, the court leaves the ruling on the table until you've done so. All right? So I don't think that is by itself an unimpeachable position. Hello?
No, we're listening. Go ahead.
Okay. And so for me, that 10-day thing, I mean, is neither here nor file, and they could have been heard within that period. And we should deal with jurisdiction on its own, issue of an ex parte application on its own. And the Supreme Court is not called the Supreme Court for nothing. When it comes to jurisdiction, I think there's a wide latitude in terms of what the Supreme Court can or cannot do. And let us also be clear that this was a matter that had to do with a constitutional interpretation. So I don't see how anybody can say the Supreme Court did not have jurisdiction. And even where they, on paper, do not have jurisdiction, the Supreme Court in many places sees jurisdiction. And all lawyers know that you can file a case in a court which ordinarily does not have jurisdiction. If the court proceeds but nobody objects, that matter will stand. The rulings will stand. It is for the Speaker of Parliament to come into court and make his arguments, straightforward, whether they agree or they don't, and what they think should be done or whether it should be set aside or not. The trajectory is worrying for me because it seems to me that the Speaker, Bagbin, who in my view is the best Speaker we have had, but on this occasion I disagree with, is telling the court that they don't have the right to do what they have done. In essence, challenging the courts. And also not giving effect to the ruling of the court because he disagrees with them. When you take that kind of position, it's an affront to the court. You can't come to the same court and suggest that if you set aside the thing which you are saying they ruled wrongly, and when you refuse their authority over the matter, if you disagree with the court, you still have to obey the court. You still have to go to the same court, respect them, make your argument, and ask them to set it aside. And I believe they will hear you. So we should not mix jurisdiction issues with the issue of an ex parte application.
Let me bring in Martin Kpebu on this one. And I mean, look, it didn't go the way of the Speaker. But at the very least, he went back to the same court that made the ruling and sought to correct it that way. Unlike others who called for, us to hit the streets and all of that, Dr. Toniedu, was quite adamant that he didn't think the solution to this problem could come from the Supreme Court. He expected an outcome like this. And like others, he is of the view that the Supreme Court is now predictable in the sense that their rulings tend to favor one side more than the other. Does yesterday's proceedings in any way suggest that, or do you see legal? Do you see that they followed legal tenets in giving yesterday's ruling?
Oh, Kojo, unequivocally, I'll go on the predictability. I'm sure you know me by now. I just have to say it the way it has to be, because otherwise I'll be letting down our democracy. Listen, Kojo, yesterday, Lawyer Sorry was fantastic. Look, there were too many points to be brushed aside. There were just too many. At least one could have clinched the day. This thing about ex-party, listen, Kojo, is doing violence to the very education that we had in the law school. This ex-party thing, you see, yesterday, Lawyer Sorry quoted the Barclays Bank versus Cable. It's an anomaly. It's not usually done like that. That's how come it is restricted to 10 days. So somebody comes before you, ex-party. You see that even Lawyer Baby, the Avenue Markings lawyer, you read the proceedings of 18th October. He stated that he wants it for 10 days because that is the practice. And the practice, apart from, so even though it's in the Supreme Court, yes, that's why it's CI 47, and that's also the practice. So that order that the Speaker's decision is suspended till they finish hearing the case could not have been given on an ex-party application. No, they should have given it for 10 days. So that one, 100 years, I'll tell you unequivocally that was wrong. Listen, we have to disagree with the Supreme Court. If we don't do that, they won't change. Because it's the same law. Could you let's be very clear? It's the same training we are all giving. Oh. The same training. You don't write an exams to go to the Supreme Court. No. So I was called 17 years ago, right? That exam I took, I qualified to sit on the Supreme Court as soon as I got 15 years at the bar, provided, of course, no moral turpitude and those things, right? Yes. So that exam I took 17 years ago, that's it. You qualify to sit on the Supreme Court. So you see now why people will bring in politics, etc. Because the same text we are all qualified in reading. Of course, we have different pedigrees depending on what you read, etc. Right? When you look at this thing, I don't see what is rocket science about it. It is a settled practice that when somebody comes ex-party, you limit the order for 10 days. I don't know how anybody wants to defend what the Supreme Court has done. Yesterday, I saw the court making a last-minute effort to now defend it under Article 2. Look through the proceedings of 18th October. You don't see them bringing in Article 2. So yesterday, it was too little, too late. This decision, to be honest with you, it's just, as Kweko Asare says, chipping away the trust that the court has and immediately bringing to the fore a new design when we go for constitutional review. When we're going to amend the constitution, we have to take away the power of the president to appoint Supreme Court judges because you don't get much independence. Because to be honest with you, and I'm telling you what, I can defend this anywhere, that the decision has already, I don't think, you see, so in law, yes, they can defend it that, they can do so. But that is not our practice. Ex-party order. Then you say, I'm giving the order till the end of the case. I've never heard of it. But so if you want,
Martin, if I may, you say that their justification with Article 2 is too little, too late. But yesterday, listening to the Chief Justice, what she's saying is that, look, there are circumstances under which the Supreme Court can do this. And it's special circumstances is the term that she used. And she describes what qualifies as special circumstances in this current case of Parliament. Do you disagree with her characterization?
Oh, absolutely. Absolutely. I don't see the special circumstances. Let's go back and see. Let's go back to the fact and see why there were no special circumstances. It was Friday, 18th October. The case was filed around 12:40. And I tell you, one of the most curious things you see, a case filed at 12:40. When we say filed, that's the time of payment too. When you finish paying, the case has to be put open with the open files, and then they have to go and look for the Chief Justice. Then the Chief Justice has to agree to hear it. Even that agreeing to hear it within such a short time itself raises a lot of eyebrows. And I tell you, by 2 p.m., they had gathered 5 judges to sit on this matter. Oh, Charlie, it's also still very curious, right? Now, let's go to the substance. They said, when you read the affidavit, that the NDC were going to disrupt government business. When? On Tuesday, 22nd October. Now, that was, and we were talking about, well, Friday, 18th October. So there was a lot of time. What the court should have done was to refuse to grant the application ex parte because nothing was at stake at that time. The disruption, if any, I don't admit, but let's say going by their case, was going to happen on 22nd. So the court had Saturday, Sunday. I know I did a case, Pegu number 4 versus Attorney General number 4. For cases like this, the court could have even sat on Saturday, Sunday, etc. So they should have taken time to serve the speaker. If they didn't want to do Saturday and Sunday, they had Monday. So why the rush? There were no special circumstances. That's why I told you earlier that it depends on the individual. So because the same legal training we are giving, the same exam, anybody you hear says he's a lawyer in Ghana, it's one exam, law school, you pass, that's it. The rest, then it's made up of your own idiosyncrasies, your personal likes, dislikes, your political views, etc. That is what we are reading into the text, and that is how it influences how the case is being judged. Because this thing is simple enough. Speaker of Parliament is in town. He's not going to space. He's not going to the moon. Somebody comes and wants an ex parte order against him. No, because I tell you, even simple matters that are not far-reaching, most of the time, when you go to court asking for an ex parte order, lots of judges say no, go and serve the other side. Even when they're saying that, let's use a commonest example, even when the other party is building on your land at breakneck speed, a lot of judges will say, no, I'm not granting you, go and serve the other side. Yes, but like Kofi Bento said, in law, they can grant. But I'm telling you that any practitioner, this is the work I've been doing 17 years. Right now I'm on my way to court. We've been working there, right? Speaker of Parliament, before you make an ex parte order against Speaker of Parliament, hey, who one dog? Ordinarily, say no, go and serve the Speaker. Go and serve him. You won't likely get that. You won't likely get a Speaker of Parliament, head of the coordinate arm of this government. No, much less an order till the end of the determination of the case. It's a super anomaly. Super anomaly. It's not good. It's eroded the confidence we are having in the justice system because, like I said, you even ask this. And you know what? There are people who have appeared before some of the panel members on ex parte applications, and they were told that no, we'll not grant this. Yes, there are some lawyers. If we want to extend, I'm sure if you can ask Samson Ladia any day, there's one ex parte application appeared before one of them. The guy said, no, I'm not granting this. Ex parte, not granting. So when it comes to somebody of the stature of Speaker of Parliament, don't play. It's not lightly granted. And so for the court to have said the order will stay to the end, it's eroded my confidence in the system. And you see, and it makes it worse when you look at the objection that Tadusori raised about Justice N.S. Gaiwu. There are over 10 other Supreme Court justices. I think that objection should have been upheld because the optics are bad. That here you have that there's an MPP member on the panel and he's dealing with a matter involving the MPP and the NDC. It doesn't look good. So, you see, at the time Tadusori raised it, because the Chief Justice said, he shouldn't go on and on, I just thought that means actually this is too clear. So I read it that they will uphold the objection. Only for the court to go and come back and say this is a constitutional matter, it's not a political matter. Hey, I beg to differ. It's a political matter between NDC and MPP. You don't need to be a lawyer to see that this is a matter between MPP and NDC. And to the extent that N.S. Gaiwu is an MPP member, he shouldn't be on the panel. It's simple. There are over 10 other justices of the Supreme Court. So why do we put such a person? The optics are bad. Where are we headed?
Let me bring in Prof. Ransford Jampo. Prof, look, again, the whole question of whether this is a constitutional issue or a political issue comes up. But in simple terms, the Supreme Court is being criticized that in one breath they think this way, and in another breath they don't. So one of the special circumstances that the Chief Justice stated yesterday to defend or to uphold their was that if they were to confirm that these 4 MPs no longer were members of parliament, it would disenfranchise tens of thousands of Ghanaians in their constituencies between now and the election. And they felt like that was a special circumstance that an injunction would prevent. And so the injunction stands. But there are some who say that, well, why have they not applied the same thing in previous cases like Jachikwesin or even Saul? How does this feed into the political optics of the judiciary as the final arbiter?
You know, this was the first. This was the first question you asked, and I was thinking that the first respondent would have kept to this. It's a simple matter. Yesterday, after listening to them, what I just said was that well-meaning Ghanaians should worry about why our Supreme Court is concerned about the potential non-representation of some people for less than 2 months, while some people have been denied representation for almost 4 years. And this is not a matter that the Supreme Court is not aware of. The matter was sent first to the Supreme Court. The Supreme Court said it should be sent to a High Court. The High Court sat on the matter. It's been go and come adjournment for 3 years, and I'm told after 3 years, that court is saying it has no jurisdiction. And we are all here watching. I was quite surprised to hear how the Chief Justice was pontificating on this matter of representation or the potential for denying people non-representation, while at the same time she knew that others have been denied representation for almost 4 years. And I said that, look, maybe we live in an era where the Supreme Court no longer cares about public sentiments and opinions about how it goes about its activities. But elsewhere, judgments and the judges are also mindful that of the public policy implications and the implications of whatever they say in bringing about stability, peace, and cohesion in the general, body politic. And so I thought that they were going to handle the matter in a manner that would have quickly addressed the constitutional crisis in which we currently find ourselves. The Speaker's application for stay of execution of the Supreme Court order, I was surprised that it was completely thrown out in a manner that, in my view, disrespects the authority of Parliament and fosters the attempt to make Parliament quite subservient to the judiciary. In trying to locate sovereignty among the arms of government, at least in theory, and then if you look at things, it's a simple O-level government thing that we're all taught, that Parliament should come first, because it is only Parliament that is the arm of government that provides true representation for the people. Every Ghanaian is represented in Parliament, okay? But how many people elected President Akufo-Addo? He needed only 50% plus one to be elected President of Ghana. And do we elect our judges? No. Elsewhere, to make judges accountable to the people, they elect their judges. But in our part of the world, judges are appointed. And we know that so many considerations, including partisan considerations, are looked at in determining who becomes our judge. So, in trying to locate where sovereignty is, I believe that sovereignty is traceable to the doorsteps of the legislative arm of government for the simple reason that it provides the avenue for the total representation of the good people of Ghana. So, we cannot do anything, in my view, to upset the balance of power among the organs of government in a manner that subordinates the court, subordinates Parliament to the court. And it cannot be true that there was absolutely no merit in the Speaker's position, and hence something, in my view, could have been done yesterday to resolve the matter in a manner that would have brought a certain win-win situation. But the Supreme Court yesterday was not conciliatory at all. It was quite adversarial, to the point even that when it was shown that one of the judges was a former MPP parliamentary candidate, and so he had to recuse himself, the Supreme Court jumped to his defense and said no. And so I am quite worried. I am quite worried about the deepening of the constitutional crisis in which we find ourselves in now. I know the Speaker, given his nature and persona and principles, we all know that he's also a seasoned lawyer. And I'm sure that when he started practicing law, some people on the Supreme Court bench were not even lawyers. And so I know that he would also want to hit back. He may want to look at various constitutional provisions to hit back, and it may end up in he likely also disregarding what the Supreme Court is saying. And what, after all, can be done to him as a person? Nothing can be done to him. But the challenge is that his disrespect of the court orders. See, what the court is trying to do now, and the fact that we are now entertaining the idea that we can hold parliamentary proceedings by simply taking the matter to court, in my view, it's a bad precedent that we are setting for our democracy. But at the same time, and so what the court is doing now, in my view, is a bad precedent for our democracy. But at the same time, if the Speaker also go out of his way to disrespect what the court is doing and then the orders of the court, it may also be setting a dangerous precedent that, in my view, would disturb the harmony in the that is expected to exist within the governance, among the governance institutions. And so we are in for a deepening constitutional crisis, and this matter, in my view, wasn't a matter that was supposed to be settled at the courts. If there are elders in Ghana, if we have a council of states that is functioning, this is the time that they would have to intervene and settle matters. But it appears that we have succeeded in politicizing every institution of government. We have succeeded in politicizing every person, everybody, such that we don't have people in Ghana now who will moderating influences, who will be able to intervene in matters like this. And that was how come once upon a time, Reverend Professor Marty kept asking, now we are in a deepening constitutional crisis. This matter cannot be settled by the courts, because the legislative arm of government would also not pander to any attempt to make it subservient to the judicial arm of government. And so what is going to happen to us?
Right.
We need eminent Ghanaians. This has happened before. In the 2008 elections, power was not going to be handed over to Professor Mills with ease. I know, because at the time I was working at the IEA, I know the wise men and women, the eminent Ghanaians who intervened and spoke to people behind the scenes to ensure a successful transition. I call on them. They are alive. Most of them are alive. They are not dead. This is not a matter that the Supreme Court can settle in a manner that will bring about peace. In their process of trying to resolve this matter, I can tell you that Parliament would also assert itself and will not allow itself to be made subservient to the judicial arm of government. Right. And so what is going to happen? Chaos, deepening constitutional crisis. If there are eminent Ghanaians in Ghana, if the Council of State, for once, would want to assert its role that was given to them, the role that they were expected to perform in a manner similar to the role of Council of Elders who functioned in the Chief's Palace. If they want to perform this, then I think that we may be able to bring about some resolution of this impasse. Otherwise, if we allow things to go the way they are going, And given the current predictability of the Supreme Court, we know how the matter is likely to end, and I can also predict that Parliament would also not sit down and allow itself to be subordinated to the judicial arm of government.
Right. We are going to take a break and continue the conversation after. But it's important to note that actually the Council of State has paid a visit to the Speaker, and there's a statement from Parliament that depicts the conversation they had. The Speaker actually said to them that he will call for the reconvening of Parliament in November. Okay, let's get back to our conversation with Martin Kpebu, Kofi Bentil, and Prof. Jampo. Now, just before we re-engage them, a message has been sent in by Thaddeus Sori. Now, Thaddeus Sori, as you know, is the lawyer for the Speaker of Parliament, and he was in the Supreme Court on his behalf yesterday. I'll read it. It says, "I just listened to you on Joy FM. I don't want to call in. I don't do radio, but when provoked, I do it once in a while. I think the suggestion that a person who challenges an ex parte order does not have his law right is not only disrespectful, but shows you either did not follow or did not understand the proceedings. First of all, the law is that ex parte applications and orders are anomalies. That is hard law and supported by authorities. So you may want to admit that it is your understanding of the scope and application of ex parte applications is not the beginning and the end. I never argued that ex parte orders are not granted. That impression is wrong. Secondly, what was the urgency when there was an opportunity to hear the Speaker? I think we should show respect for one another." That's Thaddeus Sori. Kofi, I think this is probably in response to your point.
To my respected senior Thaddeus, an ex parte application is not normal in terms of how things should be ordinarily. That is why we call it an anomaly. When we say an anomaly, it does not mean it is not part of our system. Ex parte applications are part of our system. They are an important part of our system. Because as he and I know, there are many times when you have to do that simply to stop a situation which cannot be reversed. In fact, the state uses ex parte applications a lot.
But again, he says that he was not.
So let me land, please.
Yes, sure.
Let me land, please.
Sure.
So the point that has to be made is, I am not saying that ex parte applications, you challenge an ex parte application and you've done something, what he is saying. What I'm saying is that it is part of our system. And if he says, what is the agency? Like I said, we can argue law or argue politics or social policy. If you say what is the agency, you have challenged the discretion of the judges. Because it came before the judges. They will do an assessment of what the agency is and make a ruling. And I think it's similar to what my brother Martin is arguing. Basically, he's saying the exercise of discretion was not to his satisfaction, and gives all kinds of reasons why it should have gone the other way around, and he felt that would have been better. Then I heard my brother Jampo, who is a political science professor, I believe, suggest that sovereignty is in Parliament. Please, your students will be confused if you don't correct that. Sovereignty is not in Parliament. Sovereignty is in the people. And let's also be clear that it is the Constitution that is over everything in this country. Nobody or institution is above the Constitution. And it is the Supreme Court that has the sole prerogative to interpret the Constitution. To that extent, therefore, if anybody does anything in the nature of law, it is the Supreme Court that has to make a pronouncement as to whether it is proper or it is not. It is not because somebody is better than anybody. And when they talk about the predictability of the Supreme Court, respectfully, the most predictable Supreme Court in this world today is the U.S. Supreme Court. A democracy which is over 200 years old, where people's political affiliations are known, it does not make their rulings of no effect. We don't have time to go through all of that, but I just want to say that, look, if we are dealing with law, let us deal with law. What I hear is a lot of suggestions that the Supreme Court is not acting in a certain way. and people are thinking or suggesting that they should act in a certain direction for ABC reasons, my suggestion is that there are many people who think the other way. If you take what the Speaker did, for instance, the Speaker interpreted the Constitution and gave effect to his interpretation of the Constitution. And when somebody says that I disagree, but this is an exigent matter, so I'm going to go ex parte, you say you don't agree it's exigent. We've heard the other side of Parliament say they are going to go into the chamber and repeal laws. Okay? They are going to do things quickly. What is the definition of an exigency? So I'm simply saying that, look, I appreciate all the concerns, but if we are dealing with the law, let's deal with the law first. And this denigration of the Supreme Court as to the exercise of, their discretion, etc., we all think differently. I go to the Supreme Court, and it's not everything they've done to me that I'm happy about. I have cases that haven't been called, and we are not happy with everything. But this is the Supreme Court. Okay. Even if you disagree with them, you have to respect their ruling, come to the same court, and have it set aside. So, my senior, I'm saying ex parte may not be the normal thing, but it is part of our system. It is for the judges to determine whether the circumstances warrant the hearing of the ex parte and whether they should dismiss it or grant that application, which they did, and they gave them 7 days to be heard.
Yeah, Kofi.
The predictability is never a problem. The law is the law. If you make bad law, there will be an appeal or a repeal.
Yeah.
Sovereignty does not lie in Parliament. It lies in the people. And only the Supreme Court may interpret the Constitution. Right. So whatever has been done, stop us.
Okay. Kofi, I think the criticism here is about the use of discretion. But we'll come back to that. Prof. Jampo wants to make an intervention. Go ahead, Prof.
I think that Kofi Bentil has a fundamental misunderstanding of the constituents of Parliament. What Parliament is comprised of. You cannot tell me that sovereignty is not with Parliament, but is with the people. You should ask yourself, where are the people represented? In ancient Athenian Greek, where we used to practice democracy in its classical form, where all the people met together under one big tree and to decide on what they wanted to do for themselves, there was no Parliament. It got to a time with the astronomic growth in sizes of population and the complexities of the art of modern day governance, we chose representative democracy, where the people will select their representatives to go function in Parliament on their behalf. And so if you are talking about where sovereignty lies, it's where the people are all represented. And it is only in Parliament where all the people are represented. And that is why I said anybody who went to secondary school and went up to Form 5 and did O-level government know where to place sovereignty. It is with Parliament because all the people are represented there. And so if you tell me that sovereignty does not reside with Parliament and you are saying something else, it means you have a fundamental misunderstanding of the constitution of Parliament, the caliber of people, of how Parliament is composed.
Right.
It is made up of the people. And that is the reason why we cannot choose appointed people and make them superior of an institution that is fully comprised of people who are elected.
Right. Okay. I understand that we've lost Martin Kpebu, but let's look at the way forward. Now, what does Speaker Bagbin do? What are the options available to him? Kofi?
Speaker Bagbin must show that as an arm of government, he has respect for the other arms of government. And when I say so, I'm not saying he's not showing it. I think it must be more obvious. Because sometimes you do something and other people with other access to grind are going to take advantage of it. It may not be what he's doing, but it seems as if he's challenging the Supreme Court. It is not good for us. I believe that Speaker Bagbin, as he has done, should go back to the court, make an argument, and he has a fantastic lawyer in Tadiosaurus, to have it set aside or to have what he wants done. But it must be fundamentally understood by everybody that the judges of the Supreme Court are the supervisors of the realm. And when the Speaker or the President or anybody interprets the Constitution and anybody has some other conflict or other issue with that, the proper place is the Supreme Court. And the arguments must be made there in that chamber. The suggestion that the Supreme Court is doing somebody's bidding, they are not, being doing the right thing, etc. It's deleterious to the functioning of a proper democracy. So the way forward is to use the court system. The way forward is to go back to the Supreme Court and not suggest that they don't have a right to do what they have done. They should quickly rescind their decision. But to go before them and say, I hear what you have said, but this is my side of the story. Argue it and get them to make a decision in your favor. The Supreme Court can review its own decisions. But you have to make the case.
Right.
Suggesting that they are predictable, they are going to rule in a certain way, and all those things, it doesn't help anybody. We should respect the rule of law. And I again say, Professor Jampo, sovereignty is not in Parliament. Read your notes again. Sovereignty is in the people. Parliament is not sovereign. There are sovereign parliaments. Our Parliament is not sovereign, and the office of the Speaker of Parliament is subject to the Constitution.
Very well. Okay, Prof. Jampo, what options are available to the two sides of Parliament, the majority and minority? What's the best way forward for them?
I will talk about it, but I will not let the uninformed view of Kofi Bentil to fester. Sovereignty rests with Parliament. If you want to compare the three arms of government, and if you want to look at the fact that the president is not elected by all the people, and if you want to also look at the fact that elsewhere judges are elected, but in our case we appoint judges. And then if you also want to look at the fact that it is only within Parliament that the generality of the citizenry are represented, then you would say that sovereignty resides in Parliament. And this one is being settled in the literature. It is there already. So I will not let somebody who is not a political scientist to come and foist his uninformed views on me.
Well, Prof, we have less than a minute for your answer, please.
Well, I think that, look, if Council of State is up and doing, I will plead that they should intervene in this matter, because the point would have to be made. And we have to emphasize that Parliament can never be made subservient to the judicial arm of government. And I know that the Speaker of Parliament would want to also assert himself. And in doing so, we would fester or would get into a deepening constitutional crisis. This is a matter that the Supreme Court alone can settle. Let other eminent statesmen and women also join in, bring the two together and see how they can resolve the matter. Because if the Speaker decides to also disrespect the rulings of the court, then he may also be setting a bad precedent. And like I said, we may be deepening our constitutional crisis in which we are in now, and that will not be good for Ghana's democracy. And so let others join in, and then let us have a peaceful win-win resolution to this particular matter.
Thank you so much. Professor Ransford Jampo is a professor of political science at the University of Ghana. You also heard from Kofi Bentil, who is a lawyer, and earlier Martin Kwibu was with us. He's a private legal practitioner here in Ghana. Wow, Ray, what a debate, huh? Okay.